Good afternoon, everyone, and thank you so much for being here. I'm Alyssa, and I'm the Executive Director of the American Association of Jewish Lawyers and Jurists, or the AAJLJ. We're a professional organization of Jewish lawyers and jurists, and a big part of what we do is create space for serious but open conversations about legal issues that matter to our community. I'm very glad to be hosting today's program. We are joined by Yonatan Green, an Israeli American attorney and legal scholar who focuses on Israel's constitutional structure and the role of the judiciary. Yonatan is the author of Rogue Justice: The Rise of Judicial Supremacy in Israel. The book looks at how Israel's Supreme Court developed over time and makes the case that the court has taken on a much broader role in Israeli governance than was originally envisioned. It's a legal history, but it's also very much about how institutions actually operate in practice, especially in a system without a formal written constitution. Yonatan has practiced law in both Israel and New York. He was most recently a fellow at the Georgetown University Center for the Constitution in DC, and he's worked in private practice at Mobileye and helped found the Israel Law and Liberty Forum based in Jerusalem. It's important to say that Yonatan is coming from a particular perspective in the judicial reform debate. He is critical of the current scope of judicial power in Israel and argues that some recalibration is needed between the courts and elected branches. I hope that's correct, but you'll clarify that. Today isn't about resolving the debate. It's about hearing from someone whose work has shaped how this issue is being discussed. Before we get started, just a quick note on a format. Yonatan will speak first, and then we will open up for questions. As things come up, feel free to drop your questions into the chat, and we will get to as many of them as we can toward the end. So with that, I am pleased to welcome Yonatan, and I will turn it over to him.
Thank you very much, Alyssa. I hope everyone can hear me and see me well. Um, Thank you to Alyssa. Thank you very much to the AAJLJ. That's a bit of a mouthful for having me on today. I really appreciate it. And thank you especially to the participants today who have taken time out of their busy day to talk about these issues. Um, Unlike what I usually do, actually, I'm very much looking forward to this conversation. I look forward to all my conversations, but unlike what I usually do, I'd actually will do less talking and more discussion because I think this is a crowd and a group who will have very interesting and insightful and useful questions. So I'm very much looking forward to that. Um, what I'll start off by saying is that to some extent, and this is why I'm especially looking forward to this conversation, to some extent, this book that I've written, and I'm told I'm supposed to say the name of the book 3 times. So I'm going to put it right here. I don't know if you can see it. It's called Rogue Justice: The Rise of Judicial Supremacy in Israel. And I've taken the liberty of putting a link, an Amazon link, in the um, group chat. This book, to some extent, has really been written for you, for the current participants in this conversation, because I think you are mostly, obviously, lawyers or people interested in law or in the legal world. Um, Sorry, yeah, I'm trying to fix some video issues that I have here, but I think we're okay. Um, And of course, as the name of the organization suggests, you're mostly Jewish or from a Jewish background or interested in Israel, or the Jewish people, etc. So, to a large extent, this book about the legal system in Israel, you're sort of a core audience, right? Which is why I'm especially happy to talk about the book today. Now, before we get started, I have a few disclaimers and I want to address an elephant in the room, so to speak. Um, what I'm going to ask you to do, or at least some of you to do, is to suspend your skepticism, right? Or to suspend your suspicion. What I mean by that is, I'm sure that at least some of the people here, and I think naturally some people in the sort of Jewish legal community might be suspicious towards a book critical of the Israeli Supreme Court, and that's typically for two reasons. One reason tends to be more political, meaning just in terms of people's political inclinations, they tend to be less sympathetic towards the current Israeli government, current Israeli administration, and that's perfectly understandable and reasonable. And therefore, they also tend to be more skeptical towards criticism from that government or attempts by that government to make changes, etc. And of course, second of all of us as lawyers, I think, will be familiar with this. Many of us as lawyers have a sort of intrinsic or inherent sympathy for courts, especially when it comes to courts versus the elected branches or politicians. And I think that's also perfectly um, understandable. But having said that, what I'd like to do both in this conversation, I think, and of course more generally when and hopefully, if and hopefully when you read the book, is to put that aside for a moment and to really approach this issue with an open mind and really sort of willing to try and genuinely understand the issues of the Israeli legal system, which is what this book tries to do. And I'm sorry if I'm looking down occasionally. I just have a notepad here with some notes. Um, so I have one really important disclaimer, which I've started saying at the beginning of each of these conversations, which is this. I was born and raised in Israel. Israel is my home. And I'm sure, as all of you know, Israel is a marvelous place, a fantastic place, a place where my children were born, a place where I was born, a place where we will continue to live in the future. And this book is in no way a condemnation of Israel per se, not even of the Israeli legal system, of course. Most of the judges in Israel, most of the lawyers, most of the time are excellent people doing an excellent job. So this book takes a particular problem and it focuses on it, and I don't shy away from that. This is a critical book which tries to describe and then critique a very particular issue in Israeli government and society, but that should never be taken as some kind of overall condemnation of the fantastic place, of course, that is Israel. Um, Before we get into a little bit more of the substance of the book and what I do, I'm sure most of you are familiar to some extent or another with, well, at least with the fact that this has been a major controversy in Israel, certainly or especially in recent years, right? The Israeli judiciary, judicial activism, the Israeli Supreme Court, of course, the judicial reform proposals of 2023, and to some extent, they're sort of, they're, I should say, their successors or what's happening now. Um, what I think one of the things that the book demonstrates, even though this isn't quite what the book sets out to do, but I think one of the things that my book demonstrates is three key preliminary points to understand about the judicial debate or the legal debate in Israel. First of all, it's not new, meaning this issue and these critiques of the Supreme Court and this conversation did not suddenly appear in 2023, not even in 2015, not in 2012. This conversation has been ongoing, certainly gaining momentum, certainly maturing both on a public and social, political, and intellectual level. But this has been going on at least for the past 30 or 40 years, and this is something which we can go into in a moment. Um, in the sense that we find echoes of these criticisms very starkly put already in the early 80s and certainly in the late 80s. And an example of that is, Chief Justice Moshe Landau, who's one of Israel's greatest jurists of all time, in the late 80s was already very fiercely critiquing the Israeli Supreme Court after he'd already stepped down, critiquing what he thought was an overstep of the court's boundaries. And of course, there have been many others like him who have been voicing these objections to what the Israeli Supreme Court was doing. So, first of all, this is not a new issue, and certainly not a new, I'll call it not a new argument. Second of all, also exemplified, I guess, by Moshe Landau and others, is that this is not a partisan or a purely political issue. Meaning, this is not one side of the political divide, be it right or left, trying to win an argument against the other, trying to gain points for itself against the other, in the sense that the people who have been critiquing the Supreme Court over the past 30, 40 years have been absolutely bipartisan on the far left, on the far right, on everything in the middle. Many clear centrists, and I mentioned the name Moshe Landau. Other clear examples might be Professor Yav Dotan or the famous Professor Ruth Gavizon, Zichronah Livracha. And Professor Daniel Friedman, who was the dean of the Tel Aviv Law School, another excellent example. So this is historically has not been a partisan issue in the sense that it has not been one political side or one political side of the aisle which has been advancing these arguments or making these criticisms. Finally, I should say that many of these issues, many of these criticisms have not come from politicians at all, meaning much of the criticism against the Supreme Court and against what it has done over the past 40 years comes from both scholars and at that, Israel's top leading, most respected, most widely acclaimed legal scholars, political theorists, sociologists, etc., meaning not solely from politicians. And of course, it's also been developing very much as a grassroots organization, as something with, or as a grassroots movement with major support from very large segments of the Israeli electorate. And I'm mentioning that also in the sense that this is not just a bunch of politicians who came along one day and said, hey, we need to enact some kind of change or we need to do some kind of power grab. Meaning, even if that is true, and even if you do think that's what happened, then at least you should know that these critiques have been supported by scholars and legal I'm muting someone. Sorry, scholars and legal experts across the spectrum. Um, I think what's interesting here, when this is one of the main reasons I've written the book, is that I'm sure, and especially the people in this group, the participants of our conversation today, I'm sure that many of you, and if not, maybe even most of you, maybe all of you, are extremely knowledgeable and extremely well informed about the Israeli legal system, about Israeli current affairs, maybe about Israeli politics, and all these things. However, the fact of the matter is that there are profound barriers to understanding what's happening in Israel, and especially on this issue, which is a specialized issue. Um, Obviously, the main barrier to that is a language barrier. I'm taking the liberty of assuming that most of the people here do not speak fluent Hebrew or read fluent Hebrew. They cannot easily engage with a serious sort of academic article in Hebrew or with a Supreme Court decision in Hebrew, etc. And this already means that people abroad, even people who are well-meaning, even people who are curious, even people who are determined to know more, have this very significant barrier to properly understanding this issue and to understand the different sides of this debate. Um, and in that sense, what struck me, and this is one of the reasons that I wrote the book, is that you have this enormous gap, this enormous discrepancy between how important this issue is. And I think many would say that the Israeli legal system or the Israeli legal controversies is the most important issue in Israeli society and government today, excluding only Israel's physical survival. So if we put aside the question of Israel's physical survival against its enemies, the legal controversy is likely, the controversies or the legal debates is likely the most important issue. And you have this massive gap between that and the relative lack of knowledge and lack of understanding amongst people outside of Israel, including even the Jewish community, including even the legal community and the legal Jewish community, and what have you, and especially the lack of resources, the lack of the ability to understand these issues. So, having said all that, this has been a large part of the impetus for writing this book on the Israeli um, legal system. And then the last few, I suppose, sort of preliminary remarks I'll make about this book is as follows. First of all, the book, and again, I'll say the name. I'm told I'm supposed to say the name at least 3 times. Here we go again. Rogue Justice: The Rise of Judicial Supremacy in Israel. Um, this book is absolutely an argument, meaning it doesn't try and be an impartial describer, an entirely neutral describer of sort of all sides and the way everyone sees it and all the different arguments for one side or against. And there are a few different reasons for that. Um, but I think that even if you instinctively, you, the reader, you, the participant, even if you instinctively come down on the other side of this, meaning even if you, like I said at the beginning, are skeptical of this, at the very least, I should think that it's critical to understand the argument of the other side, to understand the argument the claim, the complaint of the people who have very strong objections to what the Supreme Court has done over the past 40 years and the power that this Israeli Supreme Court has amassed, and they would say unlawfully. So the court tries so sorry. So my book tries and does that and lay out that argument. But what I really want to emphasize is that the argument in my book is not me, Yonatan Green, editorializing and going off on a rant for many, many pages, but rather the vast majority of the book simply communicates to you a great deal of information which would not be available in Hebrew, meaning critics or the Supreme Court's doctrines themselves, in the Supreme Court's own words, in the justices' own words, in the way that they have described their own doctrines and their own development. And I leave a great deal, of course, I make sort of my view on these things known, but I think there's a great deal of room for your own judgment and for your own estimation of these issues, which I think can be far more effective once these things are presented to you in a very clear and methodical and analytical manner. Um, I think the most important thing that I want to say here to you right now about as a background note about the book, which I think is really critical, but maybe more broadly about this entire issue. And I think you as lawyers can appreciate this more than many others. The details matter tremendously. And this is not an issue which you can understand or which you can really create an informed opinion about simply by the sort of usual slogans or by the usual sort of headlines that characterize so much of the conversation of this issue, especially so much of this conversation abroad, outside of Israel, and not in Hebrew. And I think as lawyers, you recognize that, I'm sure you've all had that friend who's come over and said, hey, I'm going to sue this person. Am I right? Or, hey, I think this person committed a crime. Should they go to jail? And then your answer as a lawyer is invariably tends to be, well, actually, the details matter a lot. They actually are decisive. So what this book tries to do is to present those details in an analytical, methodical, doctrinal way, um, and to give you those details so that you can have a much firmer understanding of the controversies around the Supreme Court in Israel. Um, Ultimately, whatever your view is of judicial reform or the Supreme Court, Israeli government, and I shouldn't uh, emphasize, and this is an important emphasis, that the book is not about the judicial reform of 2023. The book, I should say, more like explains why some people supported that reform, or what the broader complaint is against the court. But it isn't, meaning that the reforms of 2023 serve more as the backdrop of the book and not the focus of it. Um, but what I wanted to emphasize um, is that the ultimately the details is the most important key to understanding the issue and therefore to fixing it. In the sense that any desire to fix the Israeli legal system, any desire to fix these fundamental problems must require a really strong and detailed and in-depth understanding of the issues. It is impossible to address a problem and to fix it without first understanding it. And that is what my book sets out to do. So after that very long introduction, I'll say a few words a little bit about the substance of the book and what I try and do in the book. And then I would like to open it up for questions because, like I said at the beginning, I think that the questions may well be the most important and interesting part of this conversation. Um, the book is built in a way that it tries to describe what has the court done over the past 40 years and what are the core arguments against what the court has done. In a nutshell, or in a very broad sense, without doing justice to the book and these topics, we can say that the court abandoned the law in any typical or familiar sense that you as lawyers can recognize. And it abandoned the traditional role of the court or of any court in democracy as you, again, would recognize it as, yourselves as members of a Western democracy. Um, The book is built in a way where each chapter is a sort of standalone chapter. So I could read them out to you. I won't say all of them, but we sort of kick off with the judicial selection process, the way judges are appointed, and then the structure of the judiciary. Um, and then we talk more about the different doctrines that the court has developed over the years, whether it's about statutory interpretation, threshold requirements as to who and what issues can come before the court, the grounds for a review of executive action, the constitutional issues, the legal counsel to the government, what some people sometimes call the attorney general, etc. But what I want to emphasize here is that it's very methodical and doctrinal in the sense that we go one issue at a time, in a way that I hope is also helpful to people that want to even understand certain issues in isolation. Meaning, even though there is a broad picture here, and many of the various issues overlap and are intertwined, of course, I've written the book in a way that I hope that someone can learn about a specific topic in which they're interested, and they can simply open up the relevant chapter and read about it. Um, what I'll do very quickly without doing justice, because as I say, the whole point is that the details matter tremendously, and that I should say my favorite book, sorry, my favorite movie. I should say maybe I shouldn't tell this to everybody, but my favorite movie is The Matrix, and one of my favorite lines there, which I regret not putting in the book, is that when Morpheus says to Neo, "No one can be told what the Matrix is; you have to see it for yourself." So I would say here, there's only so much I can do by broadly explaining. When you read the book and when you really read the details, you see what the court has done in its own words, in the words of the critics. Only then can you get a proper understanding of these issues. But I will summarize very briefly some of the core issues and complaints. And I apologize if some of this is very familiar to some of you. Some of this might be new, but this will be maybe also a useful platform or a useful jumping point for our questions in our discussion later on. So, in terms of the judicial selection process, the short version is that the Supreme Court justices in Israel have a veto over who joins the court, meaning over the appointment of their colleagues and their successors. This is not only extremely or relatively unusual in terms of what happens in other countries, and of course there are some important exceptions, but it really is unusual and an exception in the sense that almost nowhere in the world do you have this mismatch between the degree of power that the court wields and the method in which judges are appointed. Meaning, in most democracies, in most Western countries, it's one or the other. Either judges have a much more limited role, they can't strike down legislation, other elements which limit the role of the courts, and then their appointment process might perhaps be less political or will be done by different bodies who are less accountable to the public. Or in most Western countries, wherever the courts do wield considerable power comparable to what the Israeli Supreme Court wields, then the appointment process for the justices of the Supreme Court is explicitly political, explicitly executed or done by the elected and accountable branches. Um, I won't go too much into the architecture or the technical system of the Israeli judiciary, which I do describe in detail in the book. But I will note one thing, which I think many people are not aware of. In Israel, the Supreme Court is the tribunal of first and last instance, meaning it has original jurisdiction as the High Court of Justice as the HCJ. It has original jurisdiction for a vast array of constitutional and administrative issues. That means that almost any issue of major public consequence, any major petition, right, against the government, against executive action, against the legislature, against the constitutionality of laws, etc., it originates in the Israeli Supreme Court and there it ends. There's no appeals process. There's a discretionary rehearing process, which is up to the court itself to decide upon. And this is in itself already extremely unusual and lends the court some of its tremendous power. Even in its appellate function, the Israeli Supreme Court is the first tier, I should say, of appeals, meaning it's the first tier of appeals from the district courts when those have original jurisdiction. What this means is that the vast majority of important cases in Israel, criminal or civil cases, are also appealable as of right to the Israeli Supreme Court. So again, the Israeli Supreme Court as an apex court in a democratic or Western country is extremely unusual in its access to this massive variety of cases, and again is unusual in the sense of being first and last, court of first and last instance for some of the most consequential and important cases um, in the country. Very quickly running, sort of into the more substantive parts of what the court has done over the years, and this is a very, very gross and broad summary, but I think it's worth recounting, even if we're going to do it sort of in a nutshell. Um, in the early 1980s, the Israeli Supreme Court, led, of course, in an effort or initiative led by Justice Aharon Barak. Aharon Barak is, I'm sure you know, the sort of a legendary Chief Justice of the court, who's very much credited or blamed, right? Depends how you see it, but very much, I mean, all agree that he was the decisive driving force behind many of these changes. Um, so the Supreme Court in the early 1980s developed a novel uh, mode of statutory interpretation, which the court called objective purposive interpretation. Now, unlike what it might sound like to you, there's actually nothing similar to it in any legal system in the world, certainly not in the US, because what the court does is it says, I'm going to ask not what the text means and not what the text says. I'm not going to ask what the intent is of the legislators. I'm not going to ask even what the purpose was of this statute or of this legal text. I'm going to ask what the purpose should be. And the court uses these words. It's about what the purpose should be based on abstract ideals of democracy or human rights or whatever, or the reasonable legislator or whatever it is. So the court essentially says that justices or judges should discern the so-called objective purpose of statutes of legislation. And when we say objective, we mean, and the court means, the court says this explicitly, the court means the purpose that the statute ought to have in the judge's own estimation. And then the judge will interpret or really just apply this version of the law according to this judicially invented or judicially recognized purpose, and reach the outcome that they reach, even if it runs completely contrary to the legal text, even if it runs contrary to the explicit intent and explicit purpose of the ones that enacted that legislation. So that's objective purpose of interpretation that permeates the entire legal system. In the mid 1980s and late 1980s, the court abolished what are called threshold requirements, such as standing and justiciability. And again, the court did this explicitly. Not this isn't meaning this is something that the court does in its own words by its own description. This isn't a sort of a critical description even. The court ruled that anyone can petition the court essentially for some kind of government conduct that they dislike without showing any sort of standing, without showing any sort of individualized personal harm or grievance. And of course, we can speak about that quite a bit. I think most of you would be familiar with standing in the American context of cases of controversies, etc. The same goes for justiciability. The court ruled, and this is its official doctrine, that there is no form of government action, regardless of what statutory law says, regardless of what is sort of pure policymaking or sort of pure discretionary government. There's no type of government action which falls outside the scope of the court's authority. This extends to whether to make war or not, of course, rules of engagement and everything to do with military action, national security, foreign affairs. Of course, needless to say, this applies to all forms of internal policy making, be it economic and welfare, be it other forms of domestic policy, be it immigration, et cetera, et cetera. There is simply no form of government action which falls outside the scope of the court's authority. Again, this is not an exaggeration. This is how the court itself describes its approach. I don't want to keep us too much longer, so I will briefly describe two other major developments and emphasizing that this is not the extent of everything that there is to cover. One is, of course, as I'm sure some of you might have heard, there is the unreasonableness doctrine or the doctrine of extreme unreasonableness. And one of the confusing things about this, and there are many, this is one example of many, where the court borrows a term which might seem familiar to people abroad, but when you look closely, it actually shares nothing in common with the way that that term is used abroad. Purposive interpretation is one, of course, which we just mentioned, because typically a broad purposive interpretation means interpreting a statute according to its actual purpose, the purpose for which it was intended, not a purpose that the judges invent. But another good example of that is unreasonableness. And some of you might be familiar with the unreasonableness doctrine in other jurisdictions, especially in the United Kingdom, where it was first developed in what's called Wednesbury unreasonableness. So without going too much into it, we can speak about it more in the questions. But essentially, reasonableness is a form of judicial review of executive action elsewhere. Again, reasonableness not in Israel, which simply asks, was an action so outrageous, so beyond the pale, that even if it is technically authorized by statute, we can comfortably say that it falls outside the scope of statutory authority, because the statute which authorized the executive to do so never meant or never imagined that the authority would be used in that way. So that's broadly speaking what unreasonableness means elsewhere. The Israeli Supreme Court took unreasonableness to mean that the court can review all government action based on whether, and listen carefully, based on whether the government correctly weighed the competing factors and considerations. Correctly weighed. That means that the government, not that the government consider immaterial factors or considerations. That's a different grounds for review. Not whether there was something else going on like procedural flaws or all. And I'm sure some of you who know administrative law are familiar with the other grounds for judicial review of executive action. But no, the court asks under unreasonableness, did the executive government or did the government correctly weigh the different factors? Meaning, did it reach the correct outcome after weighing the different factors? And needless to say, I think most of you will recognize this is the core of governing. This is what we have government for. We expect our government themselves to weigh different factors and considerations and to ultimately come to a certain conclusion. And what the court did by using unreasonableness is that any exercise of government authority became subject to the court's arbitrary second guessing, meaning anything the government does, even if it is completely within statutory authority, even if it is clearly within the scope of what typical executive government might do elsewhere in other countries or might have done in other times, the court simply comes along and says, we think it is unreasonable, not because it's outrageous, but because you simply reached the wrong conclusion. And therefore, we will either strike it down or, worse yet, we might simply impose the outcome that we prefer, that we think is a more reasonable one. And I should say briefly, this has extended critically to appointments at the highest levels of government. So if the law says that the prime minister may appoint a cabinet minister, or if the law says that a cabinet minister or that the government appoints the chief of staff or the chief of police or the head of the security services or whatever it is, and that might be a wide-ranging authority as we might typically expect in democracies, and it might be wide-ranging in terms of the statutory text which authorizes them to make this appointment, the court will still come along and say, no, I will decide for you whether this is a valid appointment without any basis in statutory law. I will evaluate whether your decision was reasonable, not whether it was within the statutory authority, not whether it meets some technical criteria, but rather whether it is reasonable, whether you're correctly weighing all the different considerations. And the court does and has on many, many occasions struck down or strike down executive appointments all the way up to cabinet ministers and everything in between. Finally, and of course, I'm skipping over, unfortunately, some aspects of criminal law. There's a great deal to talk about there, and there's some aspects of what we call the legal counsel to the government, which sometimes erroneously is described as the attorney general, even though this office in Israel really has nothing in common with the American attorney general, not even with a British attorney general. But unfortunately, we'll skip over those, and we might come back to them later. But of course, what we haven't addressed yet, which I'm sure you're all interested in, is the constitutional question. And here we can actually make it very simple. And I know that there's a lot of weeds here. And, in Israel, in Hebrew, we have a saying for "Merov etzim lo ro'im et hayar." There's so many trees, you can't see the forest. And I think people tend to exaggerate just how complicated this issue is. Yes, Of course, it's very complicated, but on the other hand, the broad outline of the constitutional issue in Israel is extremely easy to understand. And I'll say this very briefly. Israel was founded in 1948 without a constitution. Maybe they should have had a constitution. Maybe it was a good idea. Maybe it was a bad idea. We can have a lot of conversations about this. Um, but the fact is that Israel was founded without a constitution. And it then proceeded to function for the next 40 years as a standard Westminster parliamentary democracy with parliamentary supremacy and without a constitution. And that means, among other things, without judicial review of primary legislation. Um, this was uncontroversial in the sense, of course, some people were in favor of a constitution, but this was uncontroversial in the sense that everyone agreed and conceded and knew the obvious fact that Israel did not have a constitution and the obvious legal fact that the court could never assume the power to strike down legislation in the absence of a constitution. And of course, this is not so unusual. There are numerous countries around the world without judicial review of legislation. Of course, I'm talking about Western advanced democracies. Some of them have no constitution, no written constitution, like the United Kingdom and New Zealand. Some of them do have a written constitution, but actually explicitly prohibit judicial review of legislation. For example, the Netherlands and Switzerland. And we can talk about that some more. What Israel did have, and again, this is very straightforward, people like sort of complicating it, unfortunately, Israel had something called basic laws. And basic laws is tremendously easy to understand. From the founding of the state, from 1950, I should say, Israel, the Israeli legislature started enacting something called basic laws. And these were, and to some extent remain, ordinary laws. Basic laws were nothing but regular laws enacted in the same regular way that any other law was enacted by any majority in Knesset. No special process for enacting, for amending, for annulling, and that remains the case to this day. The only thing that made basic laws special, the only thing that made them special was that they were designated basic laws to indicate that these were draft chapters of a potential future constitution. So that was a function of basic laws. Basic laws were laws that had some institutional importance or were considered central in some way or another to Israel's governing structure, and that they were potential candidates to be part of a future constitution. To make a very long story very short, in 1995, the Israeli Supreme Court, in the famous Ben HaMizrahi case, completely arbitrarily recognized two new basic laws as Israel's new constitution. And it then decided to retroactively recognize all basic laws as Israel's new constitution, despite the fact that no one quite knew how one enacts this constitution, despite the fact that no one had ever intended these to be a constitution. And of course, they were ill-suited to it in many ways, despite the fact that, of course, the public were never aware and the legislators themselves were never aware that they were about to receive a new constitution, a new judicially enacted constitution. Justice Moshe Landau, Chief Justice Moshe Landau, who I mentioned earlier, calls this the granting of a constitution by judicial decree. And he, of course, criticizes the court that Israel is the only country in the world in which the people simply discovered magically that they had that they received the constitution sort of erupt out of the ground simply because the court said so. And the court since 1995 has proceeded to strike down legislation, to conduct judicial review of legislation based on this pseudo constitution and its vague and ambiguous content. This is a very, very, very broad overview. And of course, I haven't done justice to any of these issues. And I will reiterate that the details really do matter. Meaning it's not just that they matter, that everything I said can be disregarded if you don't have a strong understanding of the details. And this is why I urge you, of course, to read Rogue Justice, The Rise of Judicial Supremacy in Israel, which is, to my knowledge, the only book today in the world in English which makes a real effort to describe these issues in great detail. So I hope this has been at least partially useful, both to describe the book and to describe some of the problems of the Israeli legal system. And I think I don't know if Alyssa would like to handle the questions or whether I should just address things in the chat. What do you say, Alyssa? How are we doing this?
I think it's fine if you want to address things, and I'll come in if something comes up if I need to moderate. But I think you can probably read the chat.
Sure. Okay. So anyone is welcome to put in a question in the chat for everyone. I will apologize in advance. I imagine that we won't have time to answer all the questions, but please feel free if you have a question. It could be about anything that I said. It can be about anything which has nothing to do with anything that I said, and I'll be happy to answer as best as I can. So the first question I have here from Mr. Richard Fulton is, do you distinguish the reasonableness test? And you can read it as well if you'd like to in the chat. Do you distinguish the reasonableness test from rational basis, which is the US standard? Wouldn't you agree that at least a rational basis test is necessary to provide a judicial safeguard against truly arbitrary government action? The answer to you, Mr. Fulton, is absolutely yes on all counts. Reasonableness, the reasonableness doctrine, I should say, even in the even in the UK, but absolutely in the US, is distinct from the rational basis test. The rational basis test is asking, right, do you have any sort of factual reason to believe that what you're doing will lead to the outcome that you're trying to achieve? Is what you're doing completely arbitrary? Meaning there's a sort of uh, cause and effect test, meaning do you have any actual reason to believe that the effect you're looking for can be brought about by what you're actually doing? That is a rational basis test. Aharon Barak himself and the Israeli Supreme Court themselves emphasized time and again the reasonableness is completely different from the rational basis test. And the appointments example is a good one, right? If the prime minister and the government choose to appoint a government minister, right? Let's say somebody becomes minister of the interior, and the Knesset then approve that appointment. And it is completely authorized by all the statutory texts that we know, all the different statutes governing these things. When the court strikes down an appointment like that, it doesn't pretend to do that. When the Israeli court does this, I mean, it doesn't pretend to do that based on some kind of rational basis tests. There's no argument here that the appointment of a certain figure, right, or a leading politician or an expert or a general or whatever it is, there's no argument here from the court side that this is somehow irrational or arbitrary. What they're saying is you're wrong. You have wrongly, you have incorrectly weighed the different competing factors here, and therefore it is illegal. I would absolutely agree that a rational basis test is necessary against arbitrary government action. We have this assumption, of course, in administrative or executive in administrative law that executive action is never authorized to be arbitrary. For example, in most cases, if a statute authorizes a certain official or a certain government authority to do something, that is not authority to flip a coin, or that is not authority to do something crazy. They have to exercise their discretion. Um, I'm moving on to the next question to Sheldon Namad, and please excuse me if I'm mispronouncing names over here. The question is the excessive reasonable test the same? Oh, sorry, where am I? Oh, I see. It's almost the same question. Sorry about that. Is it the same as rational basis? So I hope I've answered the question about rational basis. I have a question here from Hal Crane, and again, I'd like to remind the viewers and the audience, please feel free to ask any further questions in the chat. Question from Hal Crane: is there any prospect for limiting the authority of the court? How can Israel be considered a democracy when the unelected court has asserted control over every aspect of Israel life? So these are two separate questions, and I'll address them separately. Of course, they're related because this first, I think, directly reflects on the second. Is there any prospect for limiting the authority of the court? Well, let me answer that. You know, there's a legal answer, and then there's a social or a societal or a sociological answer. Um, the legal answer is no. And what I mean by that is that in January 1st of 2024, the Israeli Supreme Court came out with the unreasonableness ruling, where they struck down a basic law which would have limited the court's authority in the context of the reasonableness grounds. Um, And what the court essentially did is that I should say, not overturned, but really rather completely abandoned its entire jurisprudence from the previous 30 years, because the court had always been arguing that basic laws were Israel's constitution, and that the court's authority to strike down legislation was based on these basic laws, or that was derived of these basic laws, and that these basic laws function as Israel's de facto constitution. So when it struck down a basic law, the court essentially argued that it was doing so based on vague, arbitrary, abstract principles, principles of democracy, principles of the rule of law, which of course no court, no Western democratic court has ever done. No Western democratic court has ever assume the authority to strike down legislation, much less so to strike down constitutional amendments, so to speak, alleged constitutional amendments, based solely on abstract principles that, of course, exist only in the court's minds or in the court's hearts, at least to the extent that they are the ones that implement these. The reason I'm saying all this is because, in terms of the court's own doctrine, meaning in terms of the legal doctrine adopted by the court on January 1st, 2024, the Israeli public, the Israeli legislature, the Israeli polity has no recourse. According to the court's own doctrine, today, if the court sufficiently doesn't like something, there is no method, there is no process today for the government and for the public that elects it to change the court's power. That is what the court has essentially said in the reasonableness ruling in 2024. And it should be noted, of course, this is profoundly different from other models that we see elsewhere, whether it's in the US and in other countries, where you ultimately have some method of changing, right, the country's constitutional law, whether it's some method for the public, some method outside the judge's own pure arbitrary discretion, right? Whether it's through elected and accountable officials who appoint new justices who have a different view. And of course, more typically, or at least more properly, you have the process of constitutional amendment, which in most countries it would be unthinkable for a court to strike down a duly enacted constitutional amendment. And I'm sorry that was a very long answer, but it was an important issue to address. And then your other question was, how can Israel be considered a democracy? Well, I think it's worth saying, and this is a point that I make greatly in the book, it is absolutely true that the court's lawless arrogation of political and governing power since the 1980s, over the past 40 years, is a profound flaw in Israel's democracy. Now, of course, democracy is not a binary thing, right? All countries have a flawed a degree of democracy in one way or another. We can point to almost any country with problematic aspects in terms of their democratic pedigree or their democratic functioning, etc. But I absolutely think, and this is an argument that I make in the book, what the Israeli Supreme Court has done and the status today of Israel's constitutional law and its legal system more generally, due to what the court has done, is a profound flaw in Israel's democratic character. And we should be deep, meaning people who care about democracy, people who care about self-government, and the principles of majority rule and collective liberty and public autonomy and democratic self-government, and popular sovereignty should be deeply troubled by what the court has done over the past 40 years. I have a question here for Mr. Michael Reed. Do we know the backstory of how and why a group of justices agreed to create a constitution? In short, Mr. Reed, I should say first, yes, I mean, we do know in the sense that I think the historical record is quite clear, and I have some very extensive chapters dealing with that. I have actually an entire chapter dedicated just to how this came about, meaning the creation, so to speak, in the background of the creation of the Israeli pseudo-constitution. That's I think, chapter 9 in my book. And if I haven't said it more recently enough, Rogue Justice, The Rise of Judicial Supremacy is the name of my book. And I'll put another link to the Amazon at the end of our discussion. So yes, the backstory I think is quite clear. I could elaborate a little bit, but what I should say is that my book really focuses on the doctrine itself and not on the why of it. Meaning, I don't go into what the motivations were, or of the judges were, or why, or sort of what the social and political background was, right? And of course, there are different explanations for these things, either as justifications or simply of explanations of how it happened, etc. Um, and that's not an accident, aside the fact that the book would be triple the length, and it's already quite a considerably long book. But the book would be triple the length if we had to explain also the motivations and the cultural, social backgrounds, etc. But I want to emphasize something else. I think you, as Western democratic American readers, can recognize that some of these things, for example, judges creating a constitution, are unjustifiable regardless of the background. Meaning, of course, the legal background matters, and I go into great detail there. But if we're talking about the different motivations or the different, social, political, societal, cultural background, the whole point is that there is nothing that can justify these things if you want to remain a viable democratic country. We only have a few minutes left, so I'll go through the other questions. Mr. Richard Horowitz asks, um, does the Israeli Supreme Court change the wording of a statute if it feels its wording is preferable? The answer is absolutely yes. I've given numerous examples in the book, both throughout the book and specifically in my chapter on statutory interpretation. There are frankly so many examples. I'll give one a very, very recent one, which I don't actually mention in the book, is that there's a Hebrew statute which uses the words ish ve'isha. And if any of you know Hebrew, that means, or it's actually ish ve'ishto. And that either means a man and his woman or a man and his wife, depends exactly how but typically it'll mean a man and his wife, referencing a heterosexual married couple. And the court has very recently, in the Gortler case, reinterpreted that phrase, ish ve'ishto, a man and his wife, to include same-sex couples, and this is for the purpose of adoption. Now, this is a tricky issue because so many of these issues are ones which you might agree with the outcome, or ones which you might have sympathy for the petitioners to say, hey, this is an unjust law, or this is a law I don't like, or whatever. And people have their different views. This is one example of many. People can have their different views on these things. But it is a good example just in the sense that you have a clear statutory phrase where both the people that enacted it and the legislators today have no doubt as to what it means on every single level, and yet the judges simply decide to completely ignore the literal meaning of the law. And I should say to that question, the person who put it best the person that put it best is Judge Richard Posner, who I'm sure many of you are familiar with. Judge Richard Posner wrote a wonderful essay in 2007 called Enlightened Despot in the New Republic. And you can Google it, Enlightened Despot in the New Republic by Richard Posner. And there, one of the things that he writes about the Israeli Supreme Court is that it treats statutes as first drafts. Statutes as first drafts. And I think that's a pretty good summary of the way the Israeli Supreme Court and Israeli courts often more generally, because of course this trickles down, the way that these courts treat statutory text. Mr. Stephen Greenwald has asked, how should the situation be fixed? I'm going to read the other two questions just so we know them, and then I'll answer all three together because I think we're almost drawing to a close. How should the situation be fixed, or perhaps by the Knesset, asks Mr. Greenwald. Absence of checks and balances. Yes, I'll speak to that in a moment, Mr. Kossoff. And Lydia asks, how does political public opinion affect the judiciary? Well, I'll try and answer these very briefly, and I think they are addressed in the book. So I hope you do read the book because, as I said earlier, all these conversations are ultimately relatively superficial and a high level of generality. And the whole point is that the details matter here tremendously, which is why I've written a very in-depth book on this issue. So how should the situation be fixed? Perhaps by the Knesset. I think the Knesset's attempts so far have not been successful, and one might argue that that's exactly what happened with the 2023 judicial reform. It was the Knesset's attempt to roll back just a little bit of what the court had done since the 1980s, but essentially failed to a large degree to do so. One could argue that a larger majority in the Knesset would succeed in doing so, or the larger majority with sort of a more of a view of doing of a broader societal consensus might succeed in doing so, or at least the court would be more hesitant to strike down something which it viewed as bipartisan, even though historically that's not been the case at all. Um, of course, another option is that if the Knesset or different political actors would do a better job in communicating this to the public or to opinion makers, etc., perhaps they would be more successful. And this is all speculation. Um, I propose at the end of my book, I propose a constitutional convention, constitutional assembly, which is sort of the tried and tested way of putting together a constitutional framework, which I think it's remarkable that since the founding of the state, meaning Israel had a constitutional assembly in 1949, and it perished on its first day of existence when it made itself into the legislature, made itself into the Knesset. And to me, it's quite remarkable that no one has really been suggesting that Israel simply reconvene and create a new constitutional assembly. So how should the situation be fixed? I will just say, and I hate to be pessimistic, but this is going to get worse before it gets better, in the sense that many people have already sort of been entrenched in their views of this issue, and more importantly, um, the system which the court has created has also created winners and losers. It has created beneficiaries of this system. And the beneficiaries of that system will not relinquish that power easily. And in that sense, the court right now and its beneficiaries have everything to lose by compromise. They have everything to lose by playing along and trying to put something together which is agreed by all parties. So I think we're in for a rough ride until this is resolved. I'll just say to Alyssa and to our other participants, if it's okay, I'll take the liberty to have another 4 minutes until 2:05, just to address the last few issues. And of course, I'm not offended if anybody needs to run off. I do want to say that in terms of fixing the situation, I want to say something really important, which is for all of you, which is that part of fixing the situation, right? And I didn't explain this earlier in our discussion, but part of the problem, I spoke about the difficulty of that you have or the people outside have in understanding what happens in Israel. But that difficulty it goes two ways. It's two-sided in the sense that Israelis, including even Israeli law professors and Israeli lawyers, Israeli judges, have a very difficult time understanding what happens abroad. And in that sense, I think that people who care about Israel, people who love Israel, that want it to succeed, people in Western democracies like the United States and elsewhere, can gently educate Israelis better over these issues. And if there's something which is unacceptable, or if something is genuinely seems outrageous, then you can say this. And this is something that you can better communicate once you understand the issues. Once you read my book and have a firm enough grasp of these issues, you can firmly, gently but firmly communicate this to our Israeli brethren, to Israelis like myself, about the importance of these issues and some of the really severe flaws that we have in Israel. So I think people at the AAJLJ and elsewhere, have a role to play in fixing these issues. Um, Now, I want to take a minute to answer this question by Mr. Kossoff, um, where Mr. Kossoff says, your approach does not take into account the absence of checks and balances in the Israeli judicial system. And he asks, would there be any basis for striking down a law that clearly discriminated against a minority group in Israel? And this is
Yeah,
really,
Yonatan, I'm just gonna interrupt you for a second.
please.
Since Mr. Kosov corrected his question that it should be political system instead of judicial.
Right. Sorry. Sorry, of course. Checks and balances in the Israeli political system, not the judicial system, of course. Um, and this is a really important question to answer, and I want to take just a minute to say it, even though, again, this is very brief, and I think you should read the book because I give a much more, I think, substantive answer there. And there's really two questions here. A, let us all agree just for a moment, even if it's not true, and I'm willing to push back on the argument that Israel doesn't have checks and balances, meaning parliamentary democracy and coalition government is its own systems of checks and balances, and there are other counter-majoritarian mechanisms and systems of checks and balances in Israel. And in a system which is not federative, meaning it doesn't have states, and it is not an executive presidential system, meaning it's a parliamentary, Westminster parliamentary system, the very notion of checks and balances is very, very different from the one that we find in the US and similar systems to the US. So I'm willing to push back on even the idea or the argument that Israel doesn't have any checks and balances. I think that's exaggerated. But for the sake of the argument, let's accept for a moment that Israel is severely lacking in checks and balances. And let us even say that it is desirable for Israel to have more robust checks on majoritarian power. The problem is that in any democracy, those kind of limits need to come from the people. And this is the core paradox of all constitutionalism, right? Checks and balances exist in the United States not because they're a good idea or not because of even because Hamilton and Madison and Jay argued for them in the Federalists. They exist because they were written into a constitution which was deliberated and duly enacted by a supermajority and ratified by the public in a majority of states, et cetera, et cetera, et cetera. Meaning one cannot impose counter-majoritarian mechanisms or checks and balances on parliamentary democracy without involving the public, without involving the people, without persuading the people that this is something that you need, that they need to accept upon themselves. There's simply no theory of democracy. There's no practice of democracy in the world where this is something that's acceptable, or even I should say viable and tenable. And that's exactly what the Israeli Supreme Court did. The Israeli Supreme Court came along, among other things, right, and in a nutshell said, we're not happy with this, with the Israeli system of government as is, so we will unilaterally, single-handedly introduce our own idea of what should be the checks and balances of Israel. And what's critical here to understand, this goes into some of the effects of Israeli judicial supremacy, by doing so, the court has driven these further away, meaning now the likelihood that Israelis will have a serious conversation about checks and balances and about limits to majoritarian government, et cetera, a sort of Federalist Papers moment, a Philadelphia Convention moment in Israel, that has been pushed further and further away by the court, and it has become less and less likely as Israelis lose the ability to even have that conversation because of the court's incessant intervention in these issues. And of course, then just to quickly address your other question, right? Under my approach, would there be any basis for striking down a law that clearly discriminated against a minority group in Israel? That's not, I mean, to answer your question, not under my approach, under the approach of parliamentary democracy, the way it's practiced in the United Kingdom, the way it's practiced in New Zealand, the way it's even practiced in the Netherlands and Switzerland, which you can disagree with. You can think that this is flawed or a problem. But yes, there is no basis today in Israel for striking down a law that discriminates against a minority group in Israel, for example. Now, I should say there are caveats to that. This is important because if you want there, and let's say that you and I agree, meaning I think that there should be judicial review of legislation. I'm a constitutionalist. I believe in a written constitution. I believe that you should have a mechanism where judges can strike down laws for being unconstitutional. But I believe that you need the appropriate legal instruments to do so. And you need the persuasion and the process to bring about that change, to bring about that kind of system of government where you go through the painful and difficult and trying process of persuading the public that this is something that they need. And this is really, I think, sort of in a nutshell, part of the problem of what the Israeli Supreme Court has done over the years. So really running through the questions now, how does political public opinion affect the judiciary? I should say, broadly, it doesn't to a large extent. In some broader ways, it does. I think that's a question that I can't really go into now. And it's almost speculative, meaning the court claims that public or political opinion never affects its behavior. In practice, of course, we know that's not true, right? If you have enough people with torches and pitchforks in the road, in the streets, if you have enough consensus on an issue, then probably the court will be more hesitant on a host of issues. Can I summarize the reforms being proposed now? Unfortunately, I cannot. We're just kind of out of time for that. I do address them very briefly in the book, though. And then finally, there's a question here of racism in the court in selecting Sephardic judges, even though Sephardis are a majority in Israel. I won't go into that, but I will say that it's relevant, meaning as a backdrop for all these issues, I'll say two things very quickly, and then we'll conclude with that. One is that, of course, part of the backdrop for all of these debates or for all these controversies are other broader societal rifts in Israel and different groups in Israel, whether it's Ashkenazi and Sephardi, whether it's religious and secular, whether it's Arab and Jewish, etc., whether it's right and left, whether it's liberal economic or collectivist or whatever it is. Um, what's extraordinary about the court in this sense, and I'm agreeing with Alana's question, is that the court, I'll put it this way. Professor Stephen Calabrese who's a major expert on constitutional law, has called the court a self-perpetuating oligarchy. He's called the Israeli Supreme Court a self-perpetuating oligarchy. And he's called it that because of the way that the existing justices dominate the selection process. And they are able to veto candidates that they don't like, and especially candidates that they disagree with their politics or with their background or, of course, of their approach to judicial power. And in that way, they are also able to impose their desired candidates to join them. And I'll say that I don't think the whether a judge is Sephardi or Ashkenazi matters or shouldn't matter. And I think I would even go far as to say I think the ideological makeup of the court is more important. And you could have a court which is all Sephardi, but if they're all judicial supremacists and they all are profoundly anti-democratic and abandon the rule of law, then that doesn't make anything better from my perspective. However, just to finish the thought with this last sentence, of course, that's been a major problem in terms of the way that the Supreme Court has functioned, and it is a way that the Supreme Court has managed to insulate itself from change when compared with sort of public sentiment and the electorate and the makeup of the electorate. So I hope this was a useful and helpful conversation. I hope that you buy my book, Rogue Justice: The Rise of Judicial Supremacy in Israel. And I will hand it over to Alyssa.
Thank you, Yonatan, and thank you for addressing everyone's questions. But I think sure they have a lot more. It's great to see everybody so engaged in this subject. So thank you to everyone for being part of obviously an important and controversial conversation. And I want you to all to remember that at the AAJLJ, we really aim to engage these issues from different perspectives. We're always open to ideas and suggestions for future programs. Um, this is something that would probably be great for a debate or a panel. I'm sure there are plenty of people we can include in the future, and maybe Yonatan, you will want to come back and participate in something like that.
With
Um,
pleasure.
yes, and so if you are interested in getting more involved with the AJLJ, please become a member. Most of you here are members. I was going to say hi to some to Alan Nesbitt, who's on our board, and um, Richard Huberman, who's on our board, Steve Greenwald, of course, Richard Fulton was our executive director before me, and thank you to everybody else who joined and for having so much knowledge and bringing such great questions, and I hope you agree. And one of our upcoming webinars that's scheduled for right now will be on March 11th with Mark Goldfeder of the National Jewish Advocacy Center. So thank you again, Yonatan, so much. And I hope everyone has a great day. Take care. Thanks, Yonatan.
Thank you. Thank you, everybody.